Hello everyone, I am Aniruddha Tiwari, Director and Chief Mentor of Dronacharya Civil Services Academy. Welcome to our YouTube channel where we provide resources and guidance to those who want to become civil servants. Today we start the President of India. President is a vital part of Union Executive which is important for the UPSC Civil Services examination and state PCS exam and its three stages: preliminary, mains and the interview. This lecture will mention in detail about the President of India, how a president is elected, his qualifications, a term of office, impeachment process, pardoning power of president and vacancy in his office. The Indian President is the head of the state and he is also called the first citizen of India. He is a part of Union Executive, provision of which are dealt with Article 52 to 78, including articles related to President, Article 52 to 62. In Indian parliamentary practice, the President is the nominal executive head and the first citizen of the country. The President of India is a part of the Union Executive along with several other members of the Parliament, including the Prime Ministers, Attorney General of India and the Vice President. The President represents the nation but does not govern the nation. The Union Council of Ministers, headed by the Prime Minister, is the real executive. The Indian President rules the country on the advice of Prime Ministers and the Council of Ministers. The President is symbol of the national unity, integrity and solidarity and an apparatus of the ceremony. Constitutional provisions of the President. Article 52 of the Indian Constitution simply reads that there shall be a President of India. The various other articles related to the office of the President have been listed below. Article 52 provision in the President of India, provision in 53 the executive power of the Union, provision in Article 54 election of the President, provision in 55 manner of election of the President, provision 56 term of office of President, provision in Article 57 eligibility of re-election, provision in Article 58 qualification for the election as a President, provision in Article 59 conditions of the President's office and provision in Article 60 oath or affirmation by the President. Provision in Article 61 procedure for impeachment of the President, provision in Article 62 time of holding an election to fill a vacancy in the office of President, provision in Article 65 Vice President to act as a President or to discharge in his functions. Article 7 provision in Article 71 disputes related to the election of the President, provision in Article 72 powers of the President to grant pardons, etc. and to suspend, remit or the commute tenses in certain cases. And next, in provision in Article 74, Council of Ministers to aid and advise the President. Provision in Article 75, other provisions as to ministers like an appointment, terms, salaries, etc. And provisions in Article 77, conduct of the businesses of the Government of India. Article 7, provisions in Article 78, duties of the Prime Ministers with respect to the furnishing of the information to the President. And provisions in Article 785, sessions of parliaments, prorogations and dissolutions. Provisions in Article 111, assent to bills passed by the parliaments. Provisions in Article 112, union budget means annual financial statement. Provisions in Article 123, power of the President to promulgate ordinances. And provisions in Article 143, power of the President to consult the Supreme Court. Now, we discuss nomination. Any person may be nominated as a candidate for election to the office of President if he is qualified to be elected to the office under the Constitution. The candidate's nomination paper has to be made in the prescribed form. The form is appended to the Presidential and Vice Presidential Elections Rules 1974. The nomination has to be subscribed by the least 50 electors as proposers and at least 50 electors as seconders. The nomination paper has to be then presented to the returning officer. The returning officer is appointed by the Election Commission. Each candidate has to make a security deposit of rupees 15,000 in the Reserve Bank of India. Now, election of the President. The manner of election of the President is provided by Article 55 of the Indian Constitution. Under Article 324 of the Constitution, the Election Commission of India has the authority to conduct the presidential elections. The President is indirectly elected by the members of the Electoral College. The Electoral College comprises elected member of both House of the Parliament, means upper house and lower house, elected member of the Legislative Assemblies of the state, elected members of the Legislative Assemblies of the Union Territories of Delhi and Puducherry. This clause was added by the 17th Constitutional Amendment Act 1992. This line is very important for preliminary examination. 17th Constitutional Amendment Act 1992. In the presently year 2022 presidential elections, the Electoral College had 776 members of the Parliament and 4,033 members of the Legislative Assemblies. Next, you understood that who does not participate in the election of the President of India? This is a very important question. The nominated member of the both House of Parliament, the nominated members of the Legislative Assembly of the state, the nominated members of the Legislative Assembly of Delhi and Puducherry, all the members of state legislative councils. Next is values of votes of MPs and MLAs. This is very important as a point of exams. Values of the votes of member of parliaments means MPs and member of legislative assembly means MLAs. Firstly, we know value of the vote of MLA. It is based on the population of the states. It is calculated by dividing the population of the state by the total number of elected members of the assembly and then dividing the quotient by 1000. As per the Constitution, 84th Amendment Act 2001, currently the population of states is taken from the figure of the 1971 census. Value of vote of member of parliament. Value of the vote of an MP means member of parliament. It is equal to the total value of votes of all MLAs of all states divided by the total number of elected member of the parliament. All states, total value of the votes of all MLAs. All MLAs upon total number of elected MPs. The value of the vote of each MLA varies from the state to state. However, the value of votes of the MPs is the same. Same as it is value of the vote of an MLA. Find out total population of the state upon total number of elected member of the state legislative assembly. Suppose maximum population UP, for example, UP's population 18 lakh near about 20 lakh near about. So this upon total number of elected member of the state legislative assembly total, they find value of the vote of an MLA. Now we understood the election process. The election is held in accordance with the system of proportional representation by means of a single transferable vote. Article 53 class 3. Article 55 class 3. The voting is done in secret ballot. Under this, every elector can mark as many preferences as there are candidates contesting the election. These preferences for the candidates are to be marked by the elector by placing figures 1, 2, 3, 4 and 5 and so on against the names of the candidates in the order of preference. The counting of votes determines electoral quota. To be elected as the president, a candidate must secure a fixed quota of votes This is known as the electoral quota. The quota is determined by the dividing the total number of valid votes polled by the number of candidates to be elected plus 1 and adding 1 to the quotient. Like here, this formula electoral quota equal to total number of valid votes polled divided 2 plus 1. 2 plus 1. The counting of votes takes place in rounds. In round 1, only the first preference marked on each ballot is counted. In case a candidate secures the required quota in this phase, he is declared elected. If no candidate secures the quota in the first round, then another round of counting takes place. In this round, the votes cast to the candidate who secures the least number of votes in round 1 are transferred. This means that these votes are now added to the second preference candidate marked on each ballot. This process continues till a candidate secures the required quota. Now a question generates: why did the Constituent Assembly opt for the indirect election of the President of India? Important questions as a point of exams. During the Constituent Assembly debates, Dr. B.R. Ambedkar highlighted that directly electing the President was not desirable for two reasons. First reason is it was not practical as the administrative machinery in the country did not have the resources to conduct direct elections for India's large electorate. Second is the President of India was merely a figurehead of the executive and possessed no real executive or administrative powers. Therefore, direct elections were not necessary. Now you know election disputes about to president. The Supreme Court inquires into the decides on all doubts and disputes in connection with the election of the president. The decision of the Supreme Court is final in this regard. Qualification for the post of president: a president must meet certain requirements mentioned in Article 58 and 59 of India's Constitution to be eligible for the office of the presidency. A candidate must be an Indian citizen, should have completed 35 years of age, is qualified to be elected as a member of the Lok Sabha, should not hold any office of the profit under the union governments or any state government or any local authority. Here, it is important to remember that the office of the sitting president, vice president, governor, or a minister of the union or any state governments is not considered the office of profit for this purpose. Oath or affirmation by the president. As per Article 60 of the Constitution, the oath is administered to the President by the Chief Justice of India, or in his absence, the senior-most judges of the Supreme Court available. The President takes the oath to faithfully execute his office, preserve, protect and defend the Constitution and the law, devote himself to the service and well-being of the people of India. Conditions for President's office. Article 59 of the Indian Constitution lays down certain conditions for the President's office. He shall not be a member of either House of Parliament or a House of the Legislative of any state. If a member of either House of Parliament or a House of Legislature of any state is elected President, he shall be deemed to have vacated his seat in that House on the date on which he enters upon his office as a President. He shall not hold any other office of profit. He shall be entitled without payment of rent to the use of his official residence, the Rashtrapati Bhavan. He shall be also entitled to such emoluments, allowances and privileges as may be determined by the Parliament by law. The emoluments and allowances of the President shall not be diminished during his term of office. Next, going to discuss emolument of the President. The salary of the President of India is rupees 5 lakh per month. Pension 50% of the salary per month. Office expenses up to 1 lakh per annum. Also entitled to furnished residence, phone facilities, medical facilities, air and travel facility, and secretarial staff. Spouse of deceased presidents are also entitled to family pension at the rate of 50% of the pension of a retired president. Next, we discuss immunities enjoyed by the president. There are a number of immunities and privileges that the President of India is entitled to. These include personal immunity from legal liability for his official acts, immunity from criminal proceedings, even for personal acts during the term of office, cannot be arrested or imprisoned. Civil proceedings can be instituted against him during his term of office with respect to personal acts only after giving 2 months notice. Next is term of office. According to Article 56 of the Constitution, the President shall be in office for 5 years from the day he takes office. Also, he can be re-elected any number of times. Unlike the President of United States of America, who can be elected only 2 times, the provisions related to term of his office, he may be resigned from the office by writing to the President. The President may also be removed before his tenure on the grounds of violation of the Constitution as proved in the Parliament of India. This process is called impeachment. The President shall hold office beyond his term until his successor assumes charge. Now, going to discuss impeachment of the President. This is a very important point for civil services main examination. Article 61 refers to how the President can be impeached because of the violation of the Constitution. However, violation of the Constitution has not been articulated in the Constitution itself. The President's impeachment is a quasi-judicial act that takes place in Parliament and not in the court. The process of impeachment starts with a resolution containing charges against the President which can be brought up in either house of the Parliament. Impeachment process in the House which initiates the process. Very important line. These charges must be signed by the 1/4 of the members of the House who have agreed with the proposal to bring charges against the President. The President must be given 14 days notice before the charges are moved in the form of a resolution. Such a resolution has to be passed by a majority of not less than two-thirds of the total membership of the House. Impeachment process in the other House means after the resolution he passed in the first House, the other House shall investigate the charges. The President shall have the right to appear and to be represented in such an investigation. If the other House also agrees with the charges and passes the impeachment resolutions by two-thirds majority of the total membership of the House, the President stands removed from the office from the day the resolution is passed. You know that now till no President has been removed so far by the impeachment process in Indian history. Next, a question generates: who can or cannot take part in the process of impeachment of the President? Nominated members of the Parliament can be part of the process of impeaching the Presidents even though they did not participate in the election of the President. Elected members of the state legislature and the Union Territory of Delhi and Puducherry do not participate in the process even though they participated in election of the President. Next is vacancy. A vacancy in the President's office can arise on the expiry of his 5-year terms, or by resignation, removal from office by the process of impeachment, or by his death. Otherwise, when he becomes disqualified, when his election is declared void. What happens when there is a vacancy? Important line. What happens when there is a vacancy? Case 1. When there is a vacancy due to the expiration of the term of the sitting President, an election to fill the vacancy must be held before the expiry of the term. In case there is any delay in conducting the elections, the outgoing President continues to the hold office until the successor assumes charge. It is important to note that the Vice President does not get the opportunity to act as a President in this case. Case 2. If the office is vacant due to the death, removal, resignation or otherwise, then an election to fill the vacancy should be held within 6 months from the date of such vacancy. The new President remains in office for the full term of 5 years from the date of assumed office. Next a question generates: who acts as a President in such a scenario? When the office is vacant due to death, removal, resignation or otherwise, the Vice President acts as the President until the new President is elected. Also, if the sitting President is unable to discharge his duties due to absence, illness or any other cause, the Vice President discharges his functions until the resumes office. If the office of the Vice President is vacant, then the Chief Justice of India or senior most judge of the Supreme Court, in case of the office of Chief Justice is vacant, acts as the President. We will discuss power of the President in next class. Thank you. All the best.